My name is Ricardo Moran. I'm a principal at Schwegman, Lundberg, and Woessner. I specialize in pharmaceutical and chemical patent prosecution. And today I will speak to you a little bit about functional claiming in the chemical and biotech realm. So as most of you know, or might know, functional claiming is claiming something by what it does as opposed to by what it is. So here are just a couple very basic examples of functional claiming. So for example, an elongated strip, okay, which I think everyone's familiar who has gone to an amusement park. And the functional part of this is the this little paragraph here, which tells you that it is tear resistant when it is subjected to a force that would basically jeopardize the safety of a wearer in an amusement park environment. So that's the functional portion of that elongated strip. Or another example here from a GE case back in 1938 is these non-sagging and non-offsetting tungsten filaments. It just basically is claiming the tungsten filaments by what they do. They don't sag and they don't offset. A couple more examples here. Substantially pure carbon black, and the functional portion of that is this whole notion of the carbon black being spongy or having this porous interior. One of my favorites is this fragile gel term that comes from the Halliburton case back in 2008, which basically claims this material by the fact that it is a fragile gel. And another one of my favorites is this example from the Rochester case back in 2004, which basically attempts to claim a method for selectively inhibiting this particular enzyme or this particular substrate using any compound that will bind to it. But it doesn't specify any structure whatsoever about what this compound might be. Now, one of the things about functional claiming is that it has a lot of advantages, okay? Some of which are listed here. It now enables a broader claim scope because after all, you're claiming something by what it's doing as opposed to what it actually is. So by replacing the structural language, you are basically broadening the scope of your claim. Now, one of the great things about this, of course, is that you know, if you get a patent with this functional claim, you are going to be in a very nice situation in the sense that any competitor out there who is trying to search for your patents might have a difficult time finding them because you're using terms that do not have or claims that don't have very much structure. On the flip side, some of those positives could be also negative. Okay, so when you're contemplating filing a patent application and you want to do a prior art search, you know, assuming that other people out there have listened to this presentation, they're going to come to the conclusion that it's going to be a little bit harder to find their patents if they use functional claim elements. The other disadvantage of using functional languages is that it opens you up to a whole bunch of new art that you might not have expected because, again, you're claiming something by what it does as opposed to what it is. And also, functional elements can be so broad and indistinct that, you know, it basically leads you to a situation where you might experience a holding of lack of enablement or indefiniteness. And then on top of it is if you forget or neglect to associate that functional term with a bona fide structural element, then you're going to have a lot of troubles, as you'll see from some of the examples that we are going to discuss during this brief talk. So just to recap from what we've talked about so far, functional elements and functional claiming are generally good. Because it can take the place of structural language, especially where it is impossible or difficult to use structural language. It is also good in that it usually enables claim drafting that encompasses a broader range of structures than just a corresponding structure element. So in that regard, you get broader claim scope. So just a little bit of advice so far. I think that I'm not saying that you shouldn't use functional claiming, but I think that if you're going to do it, you have to do it with great care. Okay, you have to make sure, and in that care, you have to make sure that the functional terms are very well defined, very thoroughly defined, and on top of that, I think it is in your best interest to define it numerically, structurally. You have to put as many examples as you can so that there's no question about what it is that you're trying to claim. And you have to make sure, in that regard, to make sure that you have at least one example, the embodiment that performs that claim function. So one of the cases that we're going to review right now, albeit briefly, is the Rochester case, in which they were trying to claim the inhibition of, basically, I think people are more familiar with the cyclooxygenase 2 as opposed to PGHS2 activity. So they were trying to inhibit COX2, okay, in the human. And I'm sure that some people are very familiar with some drugs out there that actually do that. Celebrex and Bextra are two examples of that. And what Rochester was trying to do is they were trying to just basically claim any compound out there that would inhibit COX2. And you know, in all honesty, the Rochester claim was perfectly good, but the problem that they ran into, and which is part of my advice ultimately, is that there's nothing wrong with functional claiming, but you have to at least disclose one compound that achieves that claim function, at least in the context of pharmaceuticals. Another case that we're going to review now is the Halliburton case that we talked about just a minute ago. The term there was fragile gel. And, you know, in Halliburton's defense, it wasn't because they didn't have any descriptions or definitions of the term fragile gel. In fact, they had given a ton of different ways, a ton of different definitions of the term. The problem is that they didn't have very many ways of describing this gel in very physical terms, in sense of they had no numerical fallback positions. And even though they had a definition in data, the term was held indefinite because ultimately they couldn't convey to the patent office, or actually not to the patent office, but to the court, how someone with skill in the art would be able to differentiate from well to well, from condition to condition, from situation to situation, what would fall within the term fragile gel and what was outside of the scope of fragile gel. And on top of that, they couldn't distinguish, even based on their data, over gels that existed at the time. And so that was another issue that led to this term being held indefinite. So one of the final thoughts that we can take home from the Halliburton case is that I think that you would probably be best advised if you didn't use functional language at the point of novelty. But if you do, I think that you need to define this term very thoroughly, including numerically, and you darn better well make sure that those numerical distinctions help you distinguish over any materials that exist in the art. And on top, at the very least, you have to make sure that there's at least one example disclosed in your patent application that performs the claim function. Thank you very much for your attention, and I hope you enjoyed this presentation.